Good morning, everyone, and thank you for joining us. My name is Jason Cogdell. I'm one of the two benefits attorneys at ProBenefits, and I'm here with my colleague, Chris McCauley, for what is our final client webinar of 2015. We've had a year full of webinars dating all the way back to January, including our standard monthly webinars like today on different compliance and benefits topics, as well as a new format we debuted for this year and did 3 sessions of a mini webinar that was 15 minutes on a single standalone topic. We will continue that format into 2016. We'll be releasing our list of 2016 webinars very soon. If you have any specific input on particular topics that you'd like to hear more about, or anything else that that may be helpful to you for the upcoming year, we'll be happy to hear it. But thanks for joining us today, and otherwise during 2015, Chris and I enjoyed doing the webinars. We learned a lot working with you all and hearing the questions that are coming from employers on a wide range of topics. And this is one valuable way that we can try to take some of our technical and compliance expertise and share it with employers and advisors that we work with, and we're excited to do it. Our topic today is end of the year compliance review and a look at a 2016 compliance checklist. Honestly, our goal for today is to simplify. There are a lot of things going on in benefits right now, a lot of items on the to-do list of benefits and HR departments, and you all know that well. Our goal today is to simplify as we look at where we are right now, finishing 2015 and going into the next year, what some of the hot topics are and what some of the key issues are that you will want to address as we proceed. So that's what our goal is. You should have received by email, along with this webinar invitation, which was sent out last week, I believe it was Wednesday, December the 9th, a copy of our 2016 compliance checklist. If you do not have access to that, I'm going to show one on the screen in a few moments. We'll be happy to share a copy of that with you, but we will be going through the compliance checklist. Everything's on the screen today, so that you don't need to have that in hard copy in front of you, but if that is something that will help you going forward, we want to make sure that you have a copy of that. As always, your questions are welcome, and the best place to submit those questions is through the question box in the control panel on the right side of your screen. And at any point today, if you can't hear very well, you may want to just dial back in or log back in. As always, our GoToWebinar connection is only as good as the internet performs today, since it's web-based software. Anyway, before we look at 2016, I thought it may be helpful to take a quick look back at 2015 and what the key compliance developments were for the year, some of which were expected, some of which were not. And I'm not going to go through these in detail, but just so we can see it all in one place as we look at what 2015 held. Frankly, it was as eventful a year in benefits compliance as I've seen in the time that I've been working and advising in this area, because we just had a little bit of everything. We had some law taking effect. We had 2 major Supreme Court decisions, both on the federal premium subsidies and King v. Burwell announced in June, as well as the decision announced the next day in the Obergefell v. Hodges case regarding same-sex spouses and benefits under federal law. This was the first year of the employer mandate under the ACA, and large employers, over 100, have been complying or not complying with player pay this year. We learned more about wellness programs. We learned more about employer involvement in the payment or reimbursement of individual health premiums. We were not expecting the big data breaches and the increased focus on HIPAA. That is going to be a theme for 2016 and beyond. I think the big data breaches, including Target and Anthem, has served as a wake-up call that HIPAA compliance is important, and that's something that will be of paramount importance going forward. The new ACA reporting requirements are taking effect soon. They're due in the next couple of months, but this year was the year we figured out what those requirements are all about as the IRS formalized the processes and procedures. And then finally, Congress woke up after 9 months of complete inactivity regarding the ACA and acted on 2 items in September and October. First, the PACE Act at the end of September, which gave states back the authority to define what small group is for purposes of insurance rating. and carrier rules. And many states have gone back to the 50 definition instead of what was going to be the 100 definition that was going to be uniform. The second item that Congress acted on in October was that Congress repealed the automatic enrollment provision that was slated at some point to take effect for large employers, so that no longer exists. So 2015 included some expected items, some unexpected items. It included some legislation, court decisions, agency releases and guidance. It was a whirlwind of a year, and a lot has happened. As we look ahead to 2016, there's some things we know. For example, player pay continues to take effect. Now it applies in 2016 to all employers that had 50 or more full-time employees plus equivalents during the prior year. This is the first year that the new ACA reporting requirements enforced by the IRS will be in effect. There are new ACA maximum out-of-pocket rules that will take effect. So that is the known. What is the unknown is what surprises there will be and what's to come that we may not be expecting. I'm not going to try to predict the surprises, but I will tell you that what we think are three key compliance areas for 2016 are, and these are two topics we'll reference today. First, ERISA. ERISA hasn't changed, but the focus of the Department of Labor continues to increase on whether or not employers are complying with SPD requirements, Form 5500s, fiduciary responsibility. HIPAA is going to be a huge topic for 2016 following the data breaches and increased enforcement of the Federal Health and Human Services Department and other HIPAA compliance policing efforts. Wellness programs are going to continue to be a hot topic for 2016. We predict both compliance with the standard wellness rules under HIPAA non-discrimination and new EEOC guidelines to ensure that wellness programs are not discriminatory and that they remain voluntary in compliance with those EEOC rulings. So this is what we project as the list of key topics for 2016. Certainly there will be more. It's possible some of these items are changed in some form as we go in 2016, but this is what 2016 looks like at this moment. Now the checklist, and I'm going to put this on the slide, particularly for those of you that haven't had an opportunity to look at it yet. And this is just a PDF version of our benefits compliance checklist, which we lay out by topic. This is a one-page document meant to provide the big picture issues and some key specifics. If you can see that on your screen, you'll see that the ACA checklist, for example, is very detailed. There are a number of key points for 2016, some of which are not new. As an example, the fees, the reinsurance fees paid by plans, particularly self-funded health plans, and the PCOR fees paid by self-funded health plans, both major medical and HRA, those continue. No surprises. The amounts change for 2016, but the deadlines haven't changed. Really nothing new there. Really the only new things are the IRS reporting rules and then the way that the new 2016 maximum out-of-pocket limits apply for ACA purposes. But ACA detailed checklist, that's at the top of the list here, and I'll cover that at the end of the show today. On the other individual topics, we have Section 125, HRAs, ERISA, COBRA, HIPAA. Chris will say a few more words about each of those topics in just a moment. But this is the way we design our annual benefits compliance checklist to provide you as the employer an opportunity to see everything in one page and decide what's important for your organization in the coming year, what maybe you're in good shape on, what may need more attention. If you do not have a copy of the compliance checklist, we'll be happy to get another copy to you. In addition to what we sent out last week, there was a link within the compliance update sent out on Wednesday, December 9th. Also, if it would help you to have a modifiable version, so for you employers, you could adjust what's on your checklist and maybe tailor it specifically to your organization, or for those of you who are advisors and you want to modify it to your use with your clients based on their particular size or their particular needs, we'll be happy to provide upon request a modifiable version of this checklist. We provide the checklist as one of our benefits compliance services for employers and advisors we work with, and we're happy to do that. Getting back to the specific topics, I'm going to turn it over to Chris, who's going to start with Section 125.
Thanks, Jason. And before I jump into the slides in Section 125 Plan Compliance, I just want to say, talk about briefly, one thing we recommend generally is annually taking a look at all of the benefits that you offer to your employees, everything from your major medical plan all the way down to the snacks in the coffee room, and determine what rules apply to those benefits and determine whether you are complying with those rules. And so we think that annually that review should be done, and the end of the year or the new year is as good a time as any to do that review. And that's one thing the checklist is also meant to help with, is that annual review, looking at general compliance of all the benefits you offer. So with that being said, I first wanted to talk about Section 125 Plan Compliance. And the ability of your employees to pre-tax premiums for certain benefits. Generally in 2015 and probably going forward in 2016, there really aren't many changes to the Section 125 rules, if any at all. But what may have changed is your plan or your plan design. So if you have changed your plan design, potentially you need to consider whether an SPD is needed to update your plan and update your participants regarding your plan. And the first thing that potentially may need updated is the plan year basis. Hopefully we've moved past all the changes that employees are making to the renewal for their medical plan. Perhaps in the past you've changed to a 12/1 or 11/1 renewal, maybe even March 1st or April 1st have been common dates, but just determine whether your SPD includes the correct plan year basis. And again, hopefully if you have to change that this year, you won't have to change it moving forward. Hopefully those changes to the plan year have settled down now. As Jason mentioned, the definition of spouse has been an issue the last couple years with the legal challenges. I don't think anything really has changed in 2015. I think Obergefell really just solidified what we knew, and that is essentially that a spouse now under the 125 plan includes opposite and same-sex spouses, and really those individuals should, all spouses should be treated the same for 125 plan purposes. Obergefell got rid of the state of celebration rule. Essentially now all states have to recognize same-sex marriage. So really I think we know moving forward that a spouse includes both opposite and same-sex spouses. Just consider whether that's in your SPD and whether a change needs to be made. The new qualifying events for marketplace open enrollment, they were really new last year, but some employers may not have added them to their 125 SPD. Essentially, the IRS now allows an employee that has group coverage to enroll in the marketplace coverage, the federal exchange, and drop their group coverage mid-year. So marketplace enrollment is now a mid-year qualifying event that would allow employees to drop their group coverage mid-year. So if that's something you want to offer to your employees, make sure that that marketplace open enrollment is in your SPD. The Health FSA max will remain the same in 2016 as in 2015. So if you want to offer the max for 2016, that will be $25.50. Any plans that have an FSA credit or are implementing a defined contribution approach should outline that credit in the 125 plan. So if you want to offer your employees $500 for the year to allocate to a menu of benefits that you offer and allow the employees to pick and choose what benefits they want to use to pay for with the credit, that defined contribution approach, or really any flex credit you're offering to your employees, should be outlined in the 125 documents. And then finally, HSAs are becoming more common. Employers want to allow employees to participate or contribute to their HSAs with pre-tax salary contributions. So if you want your employees to do that, those HSA contributions should be listed as a benefit option and outlined in the 125 document as well. And then finally, if you have not already, if you have an FSA and you have not already adopted the rollover provision, which has been around for a couple years now, and we've seen almost all employers offering the FSA go to the rollover option because of its benefits to both the employer and the employee. If you have not adopted, revisit once again and take a look at whether that would be something good to add to your plan in 2016.
And Chris, a couple of items that we've received questions about. First, from some of our small employer clients, an issue that you are familiar with is if the small employer is not sponsoring a group health insurance plan, is the group still able to have a health FSA without the group health insurance plan?
Technically speaking, the ACA for a general purpose FSA requires that anyone eligible for the FSA also be eligible for a group medical plan. That's the technical legal answer. Potentially, if you offer an FSA to employees but do not offer them group health coverage, potentially you could be subject to some ACA penalties. With that being said, especially for small employers under 50 employees, the practical considerations are different. I think the risk in doing so, offering the FSA without the group medical plan, is relatively low. There's also some potential relief in Congress for plans under 50, for small group plans, to allow them to offer the FSA without the group medical plan. So just in summary, technically, yes, that's correct. You need to offer a group plan, but practically speaking, we still have some small FSAs that are essentially assuming the risk and continuing to offer some benefit to their employees through the FSA without offering a group plan.
And the second matter, just as an editorial comment, Chris mentioned the change in the legal definition of spouse most recently after the Obergefell Supreme Court case. Some employers have not made any changes. Some employers didn't need to make any changes, but the IRS has slowly released guidance confirming exactly what plans need to do or not do to comply with federal law. Of interest, last week, I think it was last Wednesday afternoon, the IRS released Notice 2015-86 describing specifically scenarios for both retirement plans and health and welfare plans as to what those plans need to do. Chris and I have reviewed the notice in detail. Basically, it tells us what we already knew, so we didn't gain any new information. But if there's anybody out there who's still struggling with the issue regarding definition of spouse and you'd like to see a copy of this most recent IRS notice, we'll be happy to provide that to you.
Moving along to HRA compliance. HRA compliance, also another aspect that really has not changed a whole lot in 2015, and we don't expect it really to change too much in 2016. Again, consider whether your SPD needs to be updated. These are the same considerations as the 125 plan, the plan year basis, the definition of spouse. Also consider whether you're complying with other requirements that are the result of the ACA, the summary of benefits of coverage, which needs to be distributed to all participants to provide them with information about your HRA or your deductible reimbursement plan, your co-insurance reimbursement plan. Also, as has been the case for the last couple of years, the annual PCOR fee needs to be paid and submitted by July 31st. We are sort of in a routine with PCOR fees. I think most sponsors of HRAs understand the requirement now, know what they need to do, submit the Form 720 along with the applicable fee. So if you have an HRA plan that ended at any time during 2015, you will have to pay PCOR fees that will be due July 31st of 2016. And then also just make sure you're complying with the new HRA integration rules. Essentially, standalone HRAs have gone by the wayside. For the most part, HRAs now need to be integrated with group medical coverage, so they're linked to that coverage, and eligibility is linked to that coverage as well. So you want to make sure that you're complying with the HRA integration rules. Also, you want to ensure COBRA compliance. HRA is a group health plan subject to COBRA. So make sure you understand how COBRA applies to the HRAs, what premium you can charge for the HRA, the requirement that an employee should be offered the chance to opt out of the HRA at least once a year. These are all aspects of COBRA compliance for HRAs. And finally, I just wanted to make a couple notes of requirements that do not apply to HRAs, which you may think may have applied to HRAs. First, ACA reporting generally does not apply to HRAs, and also the reinsurance fees that are due for your major medical plans are not due for HRAs as well. Moving along to ERISA compliance, as Jason noted in his introduction, ERISA compliance really has not changed. It has not changed for many years now. The requirements here have always been in place, but there's a heightened sensitivity to ERISA compliance just in this general age of health and welfare compliance. So a lot of the ERISA requirements are now again coming to the forefront. The two basic ERISA requirements that you want to make sure you're complying with is first the SPD requirement. The summary plan description is required for each ERISA plan that you sponsor, and they should be current, compliant, updated with new plan designs, on file in case you're ever required to produce them, and distributed to all plan participants. You also want to consider any WRAP SPD considerations to make sure you have a fully compliant SPD. If you're relying on a carrier booklet to be your SPD for your medical plan, you want to make sure that that carrier booklet has all the 33 required SPD items, or else potentially you may want to implement a WRAP SPD, which will essentially supplement that booklet to add the last couple items that may not be in the carrier booklet. And the second major ERISA compliance requirement is the annual Form 5500 requirement. This is the main reporting requirement in ERISA, generally applicable only to health and welfare plans with 100 participants on the first day of the plan year. So generally, plans with less than 100 participants are not required to file the annual Form 5500, and those 5500s are due by the end of the 7th month following the plan year. So just for example, calendar year plan 5500s are due the following July 31st.
Chris, a quick comment there regarding, we won't go into detail on this today, but in our work with employers, we've seen a significant need and demand for WRAP SPDs. You know, in general, the WRAP SPD is the legal document that stands on top of the carrier booklet, supplements the carrier booklet as to content, and then fills in the gaps of anything that the carrier booklet may not have regarding plan specifics, including details regarding eligibility. Over the course of time, it has been true that WRAP SPDs, while, excuse me for the screen sharing there, while WRAP SPDs, while a technical legal requirement, have really been a best practice requirement. But I think due to the complexity of benefits, due to some of the specific exceptions that many employers have regarding eligibility for spouses or variable hour employees, or fill in the blanks with all the non-standard items your plan may have, WRAP SPDs have really moved to be a best practice or even compliance need for groups of all sizes. So I know that's something that we're working with employers on. That's something Chris and I deal with often, and Chris is coordinating our new WRAP SPD advanced template process, which has been a big success so far in 2015. So if you employer or you advisors need some assistance in that area, know that's one area we can assist.
Moving along now to COBRA Compliance, COBRA Continuation Coverage Compliance for employers that are subject to COBRA. The first thing you want to do for 2016 is to determine whether COBRA applies to you as the plan sponsor. And the basic rule is that if you were an employer with 20 or more employees on a typical business day in 2015, then COBRA applies to you in 2016. So regardless of whether the number of your employees dips below 20 in 2016, if you were over 20 in 2015, you need to offer COBRA. You are subject to COBRA for all of 2016. So first determine whether COBRA applies. For those of you that COBRA does apply, confirm that your election notice has been updated to include required information regarding the marketplace and premium subsidies on the marketplace. This is not a new requirement. It's probably about 2 years old now, but it is a good requirement for employers because employers are able to put in the election notice information about the federal marketplace, the potential for employees to go to the marketplace and get premium subsidies in lieu of electing COBRA. So it offers you a chance to educate your employees about the marketplace. Maybe that will get them to go get coverage on the marketplace and save you the cost and hassle of administering COBRA for that employee. And then finally, as a general point, just confirm that COBRA is being administered for all eligible benefits. I think sometimes certain benefits are forgotten in terms of COBRA compliance, that COBRA absolutely applies to HRAs, it absolutely applies to FSAs, it potentially applies to telemedicine. It potentially applies to employee assistance plans, EAPs. It potentially applies to wellness plans, depending on whether any of those benefits are offering health or medical benefits. So you just want to make sure you know which benefits COBRA applies to, and if COBRA applies, make sure you administer COBRA. And then finally, make sure you're supplying all the required notices. There are 7 required notices, including the requirement to provide open enrollment materials. The most common required notices are the initial notice, the election notice, notice of early termination of COBRA, a notice of premium change, COBRA premium change. So those are 7 required notices, and then there's a long list of optional notices, many of which are recommended just to simplify and ease administration of COBRA. Finally, the last thing I'm going to talk about is HIPAA compliance. As Jason mentioned, with Target and Anthem and the breaches, the privacy and security of individuals' information has now come to the forefront. It's more of a focus. It should be more of a focus for employers. It's certainly going to be more of a focus in 2016 for government agencies that regulate and protect the information of employees. So the first thing you want to do in terms of HIPAA compliance is ensure that you as a covered entity, a health plan, have a business associate agreement in place with all of your business associates. Potentially that includes your broker or your third-party administrator, depending on what information is shared among those individuals. And again, you want to ensure that you have policies and procedures in place to secure the protected health information of your employees. Many of these policies and procedures are common sense, but it's important to think about what are the risks, what risks do you have, or what risks are there to your employees, and what are some soft points potentially in the protection and security of your employees' protected health information. So the first thing to do is to have a risk assessment, think of the risks, and then put policies and procedures in place to go ahead and protect that information. And then finally, you want to make sure that your wellness programs are compliant with the HIPAA non-discrimination rules, HIPAA generally, prohibits discrimination in terms of premiums based on health factors. There is an exception for wellness programs, so if you do offer a wellness program that maybe lessens the amount of the premium for an employee, you just want to make sure that that wellness program is consistent with HIPAA's rules regarding those programs.
Thanks, Chris. And I will say, as an addition to those comments regarding HIPAA, that one thing we are assessing for 2016 is how we can assist employers with HIPAA. I think HIPAA is an area of great confusion for employers and advisors. And I think, again, since it's going to be a major enforcement topic at the federal level, this is something employers need to learn more about and do more about in 2016. So I suspect that this will be a topic we'll be talking more about soon and sharing some additional compliance information. Moving forward to the ACA, and I'm not going to go through all of the ACA items line by line. You've got them on the checklist and they're on the screen, many of which are either not new or self-explanatory. I will say this, one of the big developments of 2015 regarding the ACA is what did not happen. One thing that did not happen is that player pay was not delayed any further. The ACA was not repealed or significantly modified by the Republican Congress. So really, in terms of what happened this year with the ACA, the big thing is it went forward as planned, and that's what 2016 looks like as well. On a slightly less significant note, but important, the non-discrimination rule for fully insured plans has not yet gone into effect, and it looks like it's going to be a significant amount of time before it takes effect. So one of the questions asked earlier was, can an employer contribute different amounts to different categories of employees? Well, if that plan is self-funded, the answer to that is no, because the self-funded non-discrimination rules, which have long been in effect, require employees to be treated the same as to eligibility and contribution. For a fully insured plan, the non-discrimination rule does not yet apply. So technically, a fully insured plan could contribute different amounts to different categories of employees and not violate a non-discrimination rule. There is a Section 125 non-discrimination rule that we help our 125 clients comply with, including some testing. That is absolutely a factor, but the non-discrimination rule for fully insured plans under the ACA is still delayed. Those questions get more complicated when we start looking at multiple entities who may be within the same ERISA plan or 125 plan, or entities that may have separate plans but be under common ownership. I'm not going to cover that today, but just know that these issues are still in play. And even though the fully insured non-discrimination rule did not go into effect, and that was a key development of 2015, these are items we've got to keep addressing so that employers that do treat employees differently do not walk into a situation of liability by missing either the new rule or some other consideration, such as Section 125, that may not have been considered in the process. So just a couple of quick words about that. Again, I'm not going to cover line by line the ACA Compliance Checklist. I do want to move forward and discuss two specific issues that are really the biggest ACA items and the biggest overall compliance items for 2016, and those are no surprise. Number one, any employer that has had during 2015 50 or more full-time employees plus equivalents has to comply with player pay in 2016. They have to identify all 30-hour employees and either offer them coverage that meets the ACA standards and is affordable, or the employer is subject to potential penalties in 2016. No surprise there. Hopefully every employer knows whether or not player pay applies to it in 2016 and when it applies, whether in January or at a non-calendar renewal date. So player pay is the biggest compliance issue for 2016 for many employers to avoid potential penalties. And the second item is reporting, because similarly, any employer that had, looking all the way back to 2014, 50 or more full-time employees plus equivalents in 2014 has to comply with the new reporting requirements for 2015. So if you were over 50 in 2014, you have to report for 2015, and that reporting is due in early 2016. So that's what hopefully all of you who are not exempt are in the process of doing right now, because those deadlines are approaching quickly. And this new ACA reporting is a big deal. It's a bigger deal than probably anyone expected it would be, going back 1 or 2 years before we knew exactly what the forms would look like, exactly what the process and the data would look like. But here's where we stand today. On December the 15th, we are 6 weeks away from the first deadline. The forms are due on the same schedule as the W-2s and the W-3s. January 31st is a Sunday in 2016. So both your W-2s to employees and the Form 1095-C, which is the employee statement of the new reporting requirements, must be distributed to employees no later than Monday, February 1st. One big difference between the W-2, which is provided, as you know, to every employee that earned any income for your organization in 2015, is that the 1095-C will only be provided to employees that had full-time status for 1 or more months in 2015. So either someone who was eligible for the health plan in 2015 for at least 1 month, or should have been eligible for the health plan if you'd have been following the ACA eligibility rules designed around the 30-hour requirement. So that's the first requirement, that the 1095-C be provided to the employees by the end of January. Then later in February, the IRS submittal, the equivalent to the W-3, the Form 1094-C, will be provided to the IRS, 1 copy per tax ID number, along with all copies of the 1095-Cs that were distributed previously to employees. And that Form 1094-C to the IRS is due by the end of February, or for large employers that are required to file electronically, they've got until the end of March. And that cutoff is whether or not an employer is issuing 250 or more Forms 1095-C to employees. So hopefully, if you're an employer that has to report, you know that, and you're working toward that, whether you're planning to report internally, do the work yourselves, or you're outsourcing to payroll or another third party. I am personally, as someone who's doing ACA advising on a daily basis, I'm personally finding that the level of preparation and education of employers is very low. I'm also finding that the third parties, including payroll companies, some of them are on the ball, some of them are not. But even if you're outsourcing, and even if your company has paid someone to handle the reporting, know that there is still going to be significant work involved in January, because you, the employer, are still going to have to get the forms back from the payroll vendor or other third party, review them, make sure they're right, and then be part of the submission process. So in my view, January is going to require a massive amount of work for employers, whether you're doing it yourselves or you're outsourcing. But I think that any employer that has the expectation that because the employer has outsourced, January is going to be simple, I think that is not a reasonable expectation for January. So as you think ahead to January, I think the key questions for you as employers are, number one, do we know what we're doing to get the forms prepared? Do we have the data? Who is going to be doing the forms? Do we have one person or a team of people internally that are going to be preparing the forms? Number two, where do we go for questions? What resources do we have for questions that we're not sure about? Is that something our broker and team will assist with? Is that something our payroll vendor and team, or CPA and team, or do we still need a resource? If you need some resources for knowing and understanding the forms, if you need some additional training, that's something that we can assist with. That's something your broker may be providing, so you may not need us, but let us know if that's a need for your organization, or for advisors, if that's a need for your team or your clients, because the time is drawing short, and really we've only got a little bit more than a month to get all this figured out so that these forms can be completed in mid to late January and distributed. But I never want to be the bearer of bad news, but I think January on a macro scale is going to be a major mess, and maybe one of the most difficult challenges that Benefits has seen in a long time, because this reporting is difficult, particularly for large employers that have a lot of forms and a lot of employment turnover, for whom the preparation of the individual employee forms is not going to be very simple. For employers that have somewhat close to 50 forms, not a lot of turnover, a lot of stability in employment and coverage and enrollment, doing the forms, frankly, is not going to be terribly difficult. So the forms themselves can be done, but this is something that needs to be prepared for in advance, because I think January is going to be a big challenge. So I wanted to mention that regarding the reporting. So I think that's the key. The key thing in 2016 is deal with the reporting first and player pay. Make sure you as the employer are in good shape on both of those major requirements, and then look to the secondary requirements. And Chris said it well earlier. it is always our recommendation for employers that either on an annual basis or a biannual basis that the employer list all the benefits. See, number one, what are we doing, handling the benefits right from a tax perspective? Number two, are we handling these benefits correct from a legal perspective relative to ERISA and HIPAA and ACA and otherwise? I think if you, the employer, can determine what benefit plans you have and where your trouble spots may be, then that's where to get the assistance, from us, from your broker advisor team. We are there to help you and hope to help you with those compliance considerations. Again, on the screen is a list of some of the resources that we have, and we plan to provide more in 2016 in terms of webinars and other education and training resources. And if there are any specific ways that Chris or I and our entire team at ProBenefits can help you, we'll be happy to do so going forward. Chris, any specific questions you want to address before we move on?
Yeah, Jason, I think we have about 2 questions that have been submitted. Maybe we can answer those and then stick around and answer in writing any additional questions that come in. So feel free to submit some more questions if you have them. I think the first question goes back to the requirement for the out-of-pocket maximum, and we have a question from an employer that came in that the in-network out-of-pocket maximum complies with the requirements, but the out-of-network out-of-pocket does not. And is that compliant, Jason?
The out-of-pocket rules, frankly, are more complex than I can describe in a few moments. The short answer is that there is more flexibility with the out-of-pocket limits, depending on whether these are essential health benefits or not. What would be best is for me to be able to send you something in writing that describes more in detail the OOP requirements. The base OOP requirements do apply to in-network essential health benefits. So the same $68.50 for individual coverage and 2 times $68.50 for employee family health coverage in 2016, and that applies to fully insured plans and self-funded benefits. That technically does not apply to out-of-network benefits, but the network has to be clearly defined, and essential health benefits have to be provided at not higher than the cap. So the good news is there is flexibility for out-of-network benefits there.
And then last question is basically a clarification on something that was talked about earlier. If 2 companies are fully insured under the same commonly owned plan, are they okay to treat employees in each company differently? And I guess, Jason, you can add some more, but I would say from a discrimination, a medical plan discrimination perspective, there's no issue there because it is a fully insured plan. The other consideration would be 125 discrimination rules if employees were pre-taxing premiums. I think in general it's probably okay to treat the employees differently. I think you want to avoid any potential pretext for discriminating in favor of highly compensated employees. If one of the companies had all highly compensated employees and the other company did not have any highly compensated employees, I think you want to avoid discriminating in favor of the company with highly compensated employees basically as a pretext there. But in general, I think if you have 2 different companies and you have an objective business reason for treating them differently, I think that wouldn't be a problem.
Well said, Chris. To everyone, thank you for joining us today. We're at our 11:45 mark, so we want to go ahead and close out the presentation portion. If you have either submitted a question to us in writing that we have not gotten to yet, or if you would like to submit a question in writing in the next few minutes, feel free to do so. Chris and I will hang around and answer any of those written questions for the next 5 to 10 minutes. Again, thank you for joining us, and certainly Merry Christmas and Happy Holidays to you and your family. And we look forward to working with you in 2016. To everyone, thank you for joining us today. Have a great afternoon.